Okay, I guess we'll call the meeting to order at 6:03. Flag salute will be led by Commissioner Juarez. Roll call, please.
Commissioner Garcia is joining us via Zoom. I believe he still needs a couple minutes. We'll get back to him. Commissioner Gonzalez?
Here.
Commissioner Salas?
Here.
Commissioner Sandu?
Here.
Commissioner Singh?
Here.
Vice Chair Juarez?
Here.
And Chair Curry?
Here. Potential conflicts of interest. Any commissioner who has a potential conflict of interest may now identify the item and recuse themselves from discussing and voting on the matter. Oral communications. At this time, any member of the public may address the commission regarding any item over which the commission has jurisdiction. No action or discussion will be taken on any item not on the agenda. Issues raised will be referred to the chairperson for review. Members of the public shall limit their remarks to 3 minutes. If it's not an item on the agenda. If it is on the agenda, you will address the commission when we're discussing that particular item. Thank you. Are we doing our special training first? Or, I'm not sure.
Good evening, commissioners. I am James McCann. I'm with the Lozano Smith Law Firm. I work with Claire, who's sitting in as counsel for the commission. I also work with Mary Lerner, city attorney. We're pleased to be able to do a presentation, a training on the Brown Act for you. Many of you have probably heard about the Brown Act. You may be well versed in it, or it may be something that's new, but in either case, it's a critically important topic for you to understand because it applies to every single meeting that you have, and it can apply to your discussions even outside of meetings. And so it's important to kind of understand the boundaries of it and how to navigate that. And that's really what we'll be talking about. Sometimes these trainings can go on for a fair amount of time because it is a large topic. But the request was, and I think wisely so, to break this down into more palatable increments for you. And so we're just going to be doing a half hour or so as a high level overview tonight. And then really, I think within that half hour, we're also going to have time to have a discussion to, how you can ask questions, and feel free to interject with questions as I'm going through my slides. It's not that you have to wait until the very end, but if you want to wait till the very end, that's fine as well. And we can kind of have a Q&A if you have any questions.
James, if you don't mind me jumping in here real quick, commissioners, Rob Terry, Deputy City Manager. If you would like to, considering that we do have some people in the audience that are here for public hearing items, and the fact that this training could take 30 to 45 minutes, would be within the commission's jurisdiction if they would like to adjust on the agenda. Have the special training after the public hearing item, if you would prefer to do that. While I think it's great content that can absolutely, public to hear, Brown Act training, of course, is more for that's really going to be important. Respectful of everyone's time, if it would be the commission's desire, you could move the public hearing item up on the agenda, and then we could have the training that way. We're not taking away from everybody's evening unless they want to be there. Welcome to stay by all means.
Right. I was going to actually ask if it's okay with the attorney to wait for this training till the end, because we have public in attendance and they probably want to go home. And this way, if they desire to leave, they can do that and we can stay for the training.
Yeah, the attorneys are stuck here with us regardless.
Okay, well,
So
let's do that. Then we'll probably move to regular business and leave the training until the end if that's okay with
James,
everyone.
is that gonna work for you?
Yes, that's
Yeah,
fine.
My
Thank you.
apologies. We actually meant to put that way on the agenda.
That makes perfect sense. Thank you.
Thank you.
Consent calendar. All items listed under consent calendar are considered routine. The complete consent calendar will be enacted by one motion by roll call vote. For purposes of discussion, any commission member may have an item removed from the consent calendar and make part of the regular agenda. The commission can then approve the remainder of the consent calendar. Consideration and necessary action on the minutes of the May 23rd, 2022 meeting.
I move that we approve the consent calendar.
I'll second that.
Roll call, please.
A motion made by Commissioner Salas, seconded by Gonzalez. Commissioner Sandu,
Yes.
Commissioner Singh,
Yes.
Commissioner Juarez. Commissioner Garcia is still out. Chair Curry.
Yes. Statement regarding public hearings. During the public hearing, I will first ask for staff's comments and reports on the item being discussed. After staff's presentation, I will then open the hearing to the public. I will then close the public hearing, at which time no member of the public shall address the commission unless specifically asked by a member of the commission through the chair. The Planning Commission will then discuss the matter among themselves and take action on the item being considered. Consideration and necessary action of a resolution recommending a resolution to the City Council, recommending the approval of the tentative parcel map of assessor's parcel number 390-03071 to subdivide the existing approximate 3 gross acre property into 2 properties. The purpose of this request is to subdivide the parcel. It's to allow the property owner to sell, lease, develop, or finance those properties consistent with the Subdivision Map Act. Staff report, please.
Good evening, Planning Commission. This is Trevor Stearns, Contract City Planner here at the City of Selma. The item before you today, like you had mentioned, is to for the tentative parcel map 2021008 to subdivide that roughly 3 acre property into 2 separate. Next slide, please. That particular property is located just south of Nebraska Avenue between Mitchell and Thompson Avenue, APN listed there. And that site right now is currently vacant with, I believe, 2 residential structures that are on site. That site is planned and zoned for medium density residential, and it's R17 is the zone district. Proposal tonight is to recommend to the City Council approval. Background and history. We briefly went over it, that the site is primarily vacant. However, in the past, it's been used as farmland. But now it's currently not being used as that. It's just kind of vacant land with those 2 residential structures on property adjacent to the existing commercial use over there on Thompson in Nebraska. There's the location. Right there between the economy market and the apartment complex, just and north of the existing located on Sunset Boulevard. Map and the parcelization that's being proposed, parcel 1 being the larger of the 2. Site and parcel 2 that project area. Project qualifies for a categorical exemption of minor land division. because the tentative parcel map is the only item being considered tonight, it falls right within that exemptions description. And the intention for that proposal is because that there is no development being proposed. Right now, it's just the subdivision of, I'm sorry, of the one parcel into the two parcels. So to round it out, staff is recommending that planning commission approve a resolution to the city council recommending the approval of tentative parcel map for 2021-0008, along with the consideration and approval of the notice of exemption. That concludes staff's presentation. Answer any questions or concerns that starts this project.
Quick question, please. So on parcel one, is there anything specifically proposed? Are we just discussing subdividing the land?
Right now, we're just discussing subdividing the land. Currently, the land use allows for the development of single-family homes, but there is no zone change or general plan amendment. As of right now, if the subdivision does get approved, then they can only propose the development of single-family homes.
Okay.
That's all that they could build by right, without bringing forward an additional proposal. So if they were looking to do anything that went beyond what's allowed by right, they would have to do a general plan amendment, a change of zone associated with whatever proposal they might be. Have to come back before the planning commission with its own environment action to go to this. That's what they
Okay.
So there are no two-story apartments being proposed for that property at all?
that not as part of this action. That is correct. So we have not received an official application. We have also heard that there is potential for interest in that application. It's been submitted. And if one were to be submitted, that application would have to come back before the planning commission for your review recommendation and go to the city council for that.
But it is currently not zoned for that?
That is correct. It is
So-
currently zoned R17, which would only allow for single family residents.
Only, okay.
Thank you. Questions for staff? At this point, I will open the public hearing. Comments are limited to 3 minutes. Please move to the podium, give your name and your address.
We're against having apartment. Not with business, we don't mind. A crime thing on there, if you noticed that area where they want to build is the worst crime. That there is my backyard. A lot of the oppose, we do not want. Thank you.
Thank you. The applicant wishes to comment or address the commission.
Behalf of Veronica Ortiz, who is my name is Veronica Ortiz. I am writing on behalf of my family, Evan, Cecilia Ortiz, and the late Robert. At 1936 Thompson, the corner of Thompson and Sunset. We have lived in our home since 1985. Our late father was born on that property. It has come to our attention that a parcel of land has been purchased with intentions of building apartment housing. Several residents oppose this parcel of the land. They have opposed the idea of this project due to privacy issues and crime in the area. We are aware of the housing shortage in Selma and surrounding towns. We welcome the project. We hope to welcome new neighbors soon to the area. New faces may bring new changes and opportunities to our town. Thank you very much. As a Selma resident myself, I don't live far from there. I live kind of on like Mountain View and 43 area. That area.
Sorry, one
always
second.
has-
Would you give us your name and
Oh,
address for the record?
sorry. It's Heather Solano. It's 9077 East Mountain View.
Thank you.
Just being from Selma, I feel like the housing is very limited. Like finding a good apartment in Selma is so hard. Our options are Shadowbrook, the Nebraskas, and Greenwoods. Like that, those are not places I personally want to live. I know that the apartments next to the old Save Mart are really nice gated apartments, and they haven't had any crime or anything like that. I think that new apartments would bring maybe dynamic in that area. Right now, all of that area, when you pass it, it's constantly with bums and like debris. It's not clean. So having the dog park and then maybe a new complex there that's gated and stuff could help Selma and not make it. But maybe a wall would be a good idea. Backyards, but a lot of the people have open backyards and people houses in the back of that area. So it's kind of like if you're concerned about privacy, then you're not a house in your backyard, you've privacy purpose.
Thank you. Are we? Thank you. Additional comments? I believe tonight we're just discussing, we have everything in our packet and we're discussing only the subdivision of the land.
As a reminder, the callers on the line, please use *9 to raise your virtual hand and *6 to mute yourself. Chair Curry, I don't see any hands raised, so I think we're good online.
Okay, at this point, I'm closing the public hearing and turn it to the planning for discussion.
We didn't have.
Well, the two ladies are for it. Applicant is here if we have any questions.
Separating.
Division.
Right.
It's just the division of the property and
About
there's,
time something was done with that.
I always believe not make it worse than having it vacant for people to just put debris in it, and there's already crime in the area that is that high. Maybe it's something hopefully for the police.
When they do apply for a development, then we can.
I move that we approve the subdivision of tentative parcel, of the tentative parcel that was submitted. We need to read the whole thing. The tentative parcel map APN 390-030-71.
I do second.
All right, we have a motion and a second. Roll call, please.
Include the accompanying notice of exemption.
I'm sorry, can you repeat the second? Who seconded?
I second.
Thank you. Commissioner Garcia,
Commissioner Salas made the.
oh yeah, I'm sorry. I'm calling, I was trying to get Garcia online. So we have a first by Commissioner Salas and a second by Singh. I'm checking with Garcia. He says like he messaged yes, so that's a yes for Garcia. Commissioner Gonzalez,
Yes.
Commissioner Sandu,
Yes.
Vice Chair Juarez, and Chair Curry.
Yes. Great, motion passes if you want to inform the applicant, and we'll move on to our next item.
If it's okay, just as people are stepping out of the room, just wanted to remind everybody that any actual project that would be proposed would go through the same open public meeting process, including notices being sent out to the same property owners that were notified for this action here. So everybody will have the opportunity. And if there were something like a general plan amendment and change of zone being requested as well, is also going to be posted with. There will absolutely be the opportunity for people to know if and when a project is moving forward.
Thank you. Yes,
Anyone is welcome to come and address.
you're welcome. Great, I guess at this point, we'll move to our Brown Act training.
Thank you, commissioners. So we've kind of done the initial introduction. So tonight, what we're doing then is just the Brown Act overview, and I'll wait until we get the slides up here. Why don't we just move to slide 4? Okay, so the Brown Act has actually been around for quite some time. It's been around since 1964. That's when it was enacted. It's also known as the California Open Meetings Laws, which kind of gives you the spoiler of what it's all about. It's about open meetings. It's about transparency. It's about public access and contribution to your meetings, such as the public comments and the public hearing in tonight's meeting. That's a perfect example of that. And this is such an important law that there was actually a California constitutional amendment in 2004, Proposition 59, and that requires that in construing the terms of the Brown Act, that courts have to apply the terms liberally to give access to meetings. And so if there's ever a question about, oh, does this require somebody to have access to this information, or was this a meeting under the Brown Act, that type of thing, which if it's a meeting, then there's public right of access. The court will always side, or at least always weigh in favor of granting access. So just something to keep in mind, that not only is it a scale, but there is a thumb on the scale, if you will, in terms of granting access to meetings. So then next slide, please. Then really, what does the Brown Act require? It requires that actions and deliberations of the commission and other governing bodies that are subject to it be taken openly and in public. Those actions and deliberations have to relate to matters that are within your subject matter jurisdiction. So could be discussions about a project, could be discussions about anything that you would normally have come before you, but it also extends to things such as Brown Act compliance. That's why we had to agendize the training tonight, because as part of your jurisdiction, you take action and that's subject to the Brown Act. And so that's within your jurisdiction. So it's very broadly construed. So it's not just, this doesn't relate to a project, so it doesn't relate to us. It's a lot of different topics. And so it's best to think of it as really anything that could come before you. A couple of things to note in terms of that initial point. It's actions and deliberations. So it's not just when you're taking a vote, it's when you're discussing matters within your subject matter jurisdiction. And it's whenever a majority of you are having that discussion. And we'll get into a little bit more of how that can occur and one-on-one conversations and things like that. But that's just kind of the initial idea to keep in mind. The other aspect that the Brown Act requires is that meetings have to be public. So if it is a meeting as defined by the Brown Act, then it has to be in public unless it falls within one of the narrow exceptions for a closed session. We're not going to go into closed session really tonight. I can answer questions and I can kind of give you an initial rundown of what when you're allowed to do closed session, but that's a much broader topic. But the thing to keep in mind is public access to meetings is broadly construed and it's liberally construed. And so if there's ever a question, it's going to be open to the public. And then when it comes to when you can meet in closed session, that by law is narrowly construed. And so it's not only the exception, it is very, very narrow exceptions that you have to, when you do meet in closed session, it's limited to whatever the language is on the agenda. An example of that would be risk of litigation. You might meet with legal counsel if there is significant exposure or risk of litigation. You might meet in closed session relating to negotiations for real property. Unlikely for this body, but those are examples of when closed session is permitted. The meetings and agenda packets must be made publicly available. The meeting agendas and packets, must be publicly available. So the agenda, as you likely know, has to be posted in advance of meetings. For regular meetings, it's 72 hours in advance. For special meetings, it's 24 hours in advance. But the meeting agenda packet and the agenda itself has to be made available to the public upon request. And if somebody, and that also includes, it has to be ADA accessible. So if somebody does have a disability, they need to be able to access it through a reasonable accommodation of some kind. And so in terms of the information that you receive and you're considering when making your decisions during the meetings, if a member of the public were to request that, then that would have to be provided to them. And the law is that without delay. And then the agenda must be posted on the commission's website. And that's a fairly new requirement that requires that there be a direct link to the agenda. Most public agencies have figured out how to do that. By now, it's fairly simple, but it's just kind of something to keep in mind. And that's generally where the agenda will be posted, as well as the agenda has to be posted in a publicly available location. And that's for the 72 hours prior to the meeting, if it's a regular meeting, or 24 hours before a special meeting. Yes.
I have a question. The 72 hours you're asking, as you're mentioning, those include weekends as well, like we post on Friday and it comes on
Yes, it does, yeah,
working days.
yes, it does include the weekend, but the way that that provision has been interpreted is wherever you post it has to be available to the public for the entire period of time. So it couldn't be posted inside a building that's going to be locked over the weekend. It would have to be posted outside so that it would be available. Somebody could review it for the entirety of that 72 hours.
It can go beyond that, like it can go for 80 hours, 90 hours, but at least 70, least is 72 hours.
Yes, exactly. It's not a ceiling, that's the floor. That's what you have to have. You could have it posted for much longer if you wanted to. Generally want to run that by staff if you wanted that longer though, but yeah, you could absolutely have it for longer. Any other questions about the agenda, publicly available meetings, anything like that? Okay. Next slide, please. So a basic question would be, who's subject to the Brown Act? This is going to be the city council, governing bodies, planning commissions such as yourselves, standing committees, which are very similar to the role that you have. That would be a committee that is established by resolution or other action of a governing body. They have a standing jurisdiction over a topic, maybe a budgetary committee, something like that. And so it's very broadly applied. It goes beyond that, but for purposes of really what you're doing, I think that's probably sufficient to understand that. Next slide, please. The only thing to keep in mind is there are two different types of committees. There's the standing committee, which I talked about. And so that's one that under the Brown Act has continuing jurisdiction, again, like a budget committee, and the meeting schedule is fixed by the body that creates it. So if you were to create a subcommittee that had ongoing jurisdiction, so it's a semi-long term, and it had a meeting schedule and you fixed that schedule, then that would be your standing committee, and that subcommittee would also be subject to the Brown Act. There are other types of committees called ad hoc committees, and those are committees that are established for a specific purpose and for a limited period of time. It would be to maybe consider a project in different, specifically a project for a limited period of time. And in order to be an ad hoc committee under the Brown Act, the committee has to be purely advisory, so it cannot have decision-making authority. The purpose of that committee is to consider something and then make a recommendation to you as the governing body to then make a decision. And then in order to, again, to be exempt from the Brown Act as an ad hoc committee, that the members of that committee have to be solely members of the planning commission and cannot be a majority of the commission. So it has to be two. Are there 7 of you? Sorry, I'm a little bit thrown off because of the empty seats. So then it would be 3 of you could make up an ad hoc committee. And if you had limited, if it was for a limited period, then you could potentially be exempt from the Brown Act, because all you're doing is considering something and then making that recommendation. So it is going to eventually come to a public meeting, if you will. There is a fair amount of technicality around that exemption. So our recommendation is, if you are considering that for any reason, to run it by legal counsel to make sure that you're not inadvertently going to have a meeting, a Brown Act meeting that needs to be open to the public and agendized and all that. Next slide, please. So then what is a meeting? This is under the Brown Act. It's any congregation, a majority of the members. So that would be 4 of you at the same time in place to hear, discuss, deliberate any item that is within your subject matter jurisdiction. That right away, though, it gets a little confusing because a meeting can occur even if it's not at the same time and place. And we'll talk a little bit more about that, but that's called a serial meeting. And it is a common pitfall and something to keep in mind. Another aspect of this critical aspect that I mentioned earlier is that the meeting, it's a meeting even if you don't take any action, even if there is no concurrence as to what action you would take if you were to take a vote. If you're just discussing something within your subject matter jurisdiction, then that would be a meeting. Next slide, please.
If I can,
Oh, yes.
Commissioner Garcia, Greg Garcia has a question.
Oh.
I'll read it out loud. So commissioners can discuss projects together if it is fewer than a quorum.
Technically, yes, that is generally the case, but the danger of that is that you would be limited to those individuals only. And so if you were to talk to any other commissioner about it, then you could have what's called a serial meeting. So what we recommend is to not discuss amongst yourselves projects outside of the meeting. The other consideration for that is that because of the role that you serve and you have public hearings that are taking place, there is a record of that hearing in that process and the deliberation that you're giving to that. And so if commissioners, even as a minority of the commissioners, are meeting outside of the those hearings and having discussions, then that can affect the record that's being established. And so it's best to have your deliberations and your conversations in open and public meetings when the record is being established for the decision that you're making.
Thank you so much. Most of that we are like, we know that. But one question always arises, like it's not a meeting. We live, all of us live in Selma. So sometimes it's a fair, sometimes it's a event or party. So if it happens to by chance, if we all of us present over there, we are not discussing, but we are attending meeting, it comes under Brown Act or no?
No, if you're not discussing the topics within your jurisdiction, then it's not a Brown Act meeting. And there's express provisions in the Brown Act that allow for a majority of the commission to attend social events, conferences, even meetings of other public agencies, if you're not discussing the topics within your jurisdiction. If you attended a conference and you there was a breakout session where you were talking, if you attended a planning commission conference and they were talking, and then they had a breakout session and 4 of you happened to end up in one of those breakout sessions, and as part of the curriculum of that session, you were talking about local, or you were talking about items of concern locally, that is permissible. But that would you should probably avoid that type of situation if you can, but technically that would not be, or that would be an exception to a Brown Act meeting. That's limited to conferences. So just kind of keep that in mind. If you're at a social event, then, or at lunch or anything like that, it's best to avoid topics within you know, your jurisdiction. But if you happen to be at a neighbor's party or gathering and you all ended up there, or a majority of you ended up there, that would be fine. You're not in, you know, direct violation or automatic violation of the Brown Act. The other, so that actually addresses some of the what is not a meeting. The other situations would be individual contact. So you could have one-on-one contact. You could even share information one-on-one about items that are within your subject matter. But the idea there is risk that could then become a serial meeting again if you were to have a conversation with a third or a couple more people in your case who are on the commission. we can move on to the next slide, please. Oh. Oh, we can move to that one. Yeah, the next one. Okay, so we've kind of alluded to the serial meetings idea. Serial meetings can generally occur in two ways. You have a linear or a chain meeting, and that's exactly what I was referencing before, where you have Commissioner A talks with Commissioner B, and then Commissioner B talks with Commissioner C. And again, in your case, where we usually deal with 5-member boards, I apologize. And then that person would talk with Commissioner D, and now you would have a meeting under the Brown Act, a serial meeting under the Brown Act. Another way to have a meeting inadvertently is to have a hub and spoke meeting, where you have Commissioner A talks with 3 different commissioners. Now you have a Brown Act meeting because it's technically 4 people have shared information. That can also occur, and this one is a little bit trickier to avoid, but that can also occur if you have an intermediary. So if a staff member is talking with 4 different commissioners and sharing information about what those discussions are, then you can have a hub and spoke serial meeting occur. So to avoid that, again, it's best to not discuss items outside of your meetings, or if you do, to limit it to one other commissioner. Otherwise, you're running the risk of having those serial meetings. There are exceptions to this. You can converse with an intermediary regarding your availability, of course. So if you're talking about a time and date for the meeting or unavailability, that kind of thing, then if the intermediary is talking with multiple commissioners, then there's no issue with that. And the Brown Act is also not violated if you have one-way conversation from staff to you. It's when there is also the response back, then there can be issues. In terms of email, you may all receive an email, and a good rule of thumb is to never reply all when you get those emails. If you have a question, clarification, to respond back individually. That way the email from staff, your response is only being seen by staff and not any other commissioner. And that is about it. I mean, again, it was very high level, as you were saying, Commissioner, things that you know, and we'll get into a little bit more of the nitty gritty as we go along, but we just kind of wanted to provide an introduction tonight. Any questions?
Yeah, I do have another question. So since once the email is sent to us, it happened I think 3 years back. Or somebody was not attending physically, but if someone sends his opinion on a violation of Brown Act,
It could be. I don't know the exact situation.
Once Mr. Luke, all of us are saying, okay, I'm right. So, but somebody says, okay, the agenda is very important, but I do want, but I can't be.
Oh,
That way, what is the best way to your staff member?
I mean, you could. The opinion will not be part of the vote if there's a vote taken. So, I mean, I guess it could be given to the staff member, and then at the meeting that could be disclosed. But if it were included in an email outside of, obviously, if it's in an email, then it's going to be outside of the meeting. Then that could constitute a Brown Act meeting, and not have been properly agendized and all of that. So that would be a violation.
Vote by proxy, like you can't say, oh, I'm not going to be here, so let me have vote for me.
Yeah,
or on my behalf.
Correct.
Why
Yeah,
I'm
no vote
saying
by proxy.
because it happened 4 or 5 years, I think 3. Somebody did this thing that time. The city lawyer, he said, a violation of Brown Act? That's why
Good
somebody
advice.
did it. So it was like in my mind, like, hey, this happened earlier, so wanted to. So there is also like, as Ramza said, there is no like proxy, like someone wants to vote, he has to be present online or like physically or any other way, but he can't vote without being present.
Correct.
Council about conflicts of interest, if that's okay.
Sure. Yeah, we can talk about that.
So I'm a real estate broker. Commissioner Juarez is a lender. If it happened down the road that one of the applicants that came here for a project, whatever, it ended up being in the future a client of ours. So they approached us later and said, oh, hey, I want to list my house or I want to refinance my house. And we had no knowledge at the time we voted on whatever the project was. Is that a conflict of interest in the future? Can we be sued for something like that?
So I apologize. We should probably limit our discussion to, Brown Act requirements because this is a Brown Act training.
Okay.
But I would encourage you, if you have questions about that, we can do trainings. We're, happy to answer questions regarding that. But one of the things we didn't talk about was agenda language and things like that, which we'll talk about in future trainings. But the Brown Act and the limits of what you can discuss, it's established by your agenda. And so because we've set the agenda as the Brown Act training, I don't want to go too far afield because members of the public may want to participate in that conversation about conflicts of interest as well.
I would just recommend if there are several questions that might go outside of the scope of just one specific item like the Brown Act, but that you would like to have some open dialogue with the office, questions like that, we could schedule a workshop for where we could talk about commission roles and responsibilities in a broader format. That would allow us the ability to then have a little more open dialogue still in the public realm, but be able to answer some more of those questions that you have, such as that one and beyond. If you would be interested, we'd be happy to agendize that as well.
Yeah, I think so, please, because we have new commissioners and always the conflict of interest, the appearance of a conflict of interest has always been a critical topic. And, yeah, if we can cover that, it would be great.
Yeah, we'll get something onto the agenda. In the meantime, if the commissioners could, if you make notations of items that you would like to discuss and be ready for those items during the work. Any of those type of questions to me, and we can make sure they're provided to the legal. Top content is going to be as
James, if I may, Commissioner Garcia has another question. I'll read it from the screen. Can one person have a private meeting to discuss a project with the other members individually or try to sway a project?
So
Like an
the answer to
applicant?
So the answer, I think, if I'm understanding it correctly, would be no to both of those for different reasons. So to have those private meetings, you could have the serial meeting occurring. So if you're having that private meeting with 4 different people, or if you have it with one person and then they go on and have a conversation with somebody else and so on, then you could have that serial meeting. So at minimum, you would have serious risk there. The other reason, and without getting too far afield, is the idea, again, that you want the public to be able to participate in the deliberations. And so having those conversations outside and swaying or trying to develop what the law calls a concurrence or an agreement on what you would do once you get here, that's also a concern under the Brown Act.
So how do we address, for example, if an applicant had contacted a commissioner on their phone and said, hey, by the way, this is going to come, in front of you. Can I count on your support, or whatever the question might be?
Well, members of the public are welcome to contact individual members. And in fact, a member of the public could contact every single one of you. And as long as you're not sharing amongst yourselves what the content of that conversation is, there's no Brown Act concern.
Okay, thank you.
Any other questions? Okay, thank you again.
Thank you. All right, oral communications. At this time, any member of the public may address the commission regarding any item over which the commission has jurisdiction. No action or discussion will be taken on any item not on the agenda. Issues raised will be referred to the chairperson for review. Members of the public shall limit their remarks to 3 minutes. I don't see anyone here, but is there anyone online?
As a reminder to the callers on the line, please use *9 to raise your virtual hand and *6 to unmute yourself. Chair Curry, I see no one online.
All right, at this point, I'll entertain a motion to adjourn. All right, meeting adjourned at 6:55. That was pretty timely, I guess. Thank you.